Hey, I'm Janet Gemmel with Cape Fear Family Law. I'm going to talk to you today about the Brown versus Brown case. It's a published opinion out of the North Carolina Court of Appeals that came to us in May of 2023. It's from Onslow County, right here on the east coast of North Carolina, and it involves a military pension. This case was heard by the Honorable Judge James L. Moore Jr. in Onslow County. And of course, it went up on appeal after wife was allowed to receive part of husband's military pension after bankruptcy. Yeah, it's a really interesting case. And the esteemed and wonderful attorney Jonathan McGirt out of Wake County did the appeal. Let's back up and just cover the facts real quick, okay? These parties were married in 1994. They separated in 2011 and eventually divorced in 2012. But back in 2011, wife filed for equitable distribution. Now, equitable distribution can take a while, usually a year or two to get through trial in some counties in North Carolina. In the counties where we have family court, it's much quicker. And in some counties in North Carolina, it can take years, plural. So it was clearly taking more than 2 years because in 2013, husband went and filed for bankruptcy. Now, bankruptcy is a federal proceeding. It is not state. Equitable distribution is state. It's handled by the state of North Carolina, and it is not. So if you move to South Carolina and you have a claim here, we don't care what South Carolina is doing. But bankruptcy is federal. It is the same across all the states, for the most part, and it is handled there. And so husband filed for bankruptcy in the Eastern District of North Carolina. Now, here's the interesting part. When he filed for bankruptcy, the equitable distribution claim was still open, and he not only listed wife as an unsecured creditor, but he also listed the equitable distribution claim. And he listed wife's attorney and the address for her attorney for that equitable distribution claim. And we know, in fact, that everybody, wife and the attorney, received notice of the bankruptcy. Now, when bankruptcy occurs, we all know there's an automatic stay that happens. That means that equitable distribution claim is stayed. But there's things that the wife could have done. She could have filed relief. She could have filed to ask the bankruptcy court to proceed with the equitable distribution claim. Or she could have asked for a lift of the automatic stay, and we know that she didn't do any of those things. Now, in 2018, 4 years later, after $60,000 of payments, husband's bankruptcy was discharged under Chapter 13. Now, was that the end of it for him? No, because in 2019, wife went back and filed a motion for interim distribution under the equitable distribution claim that was finally back open in her eyes. And husband turned around and filed a motion to dismiss, alleging the discharge of the bankruptcy. Wife also went back and filed a motion in the bankruptcy court asking them to reopen it to determine whether or not the military pension was in fact discharged. It was a dischargeable asset under the bankruptcy court. The bankruptcy court came back and said, we don't have jurisdiction for two reasons. One is that we have concurrent jurisdiction with North Carolina on this issue. But when husband turned around and said, hey, I'm filing my motion to dismiss and I'm claiming my discharge as an affirmative defense, we lost jurisdiction. So the bankruptcy court said, no, North Carolina, you could handle this issue. The court went into a rather long review about whether or not it was an interlocutory or a final order. I'll let you read that if you want to. It's not really relevant for what I want to talk about today, which is whether or not a Chapter 13 bankruptcy after discharge does away with a spouse's right to a military pension. So let's find out what the Court of Appeals actually said about that issue. There's a law called the USF SPA, and that's the acronym for the Uniformed Services Former Spouses Protection Act. The case went into a pretty significant review of prior case law. It started off talking about the Perlow case. One of the things that it talked about at length was under a Chapter 7 bankruptcy. The bankruptcy trustee is both a lien creditor and a bona fide purchaser. Under that, the non-filing spouse, or the person who did not file for the bankruptcy, their vested interest of property is lost, and the equitable distribution claim is lost. Now, there are some things they could do. They could file a lift of the stay. They could file for the bankruptcy court to hear their equitable distribution claim, or their ED claim, but they didn't do that, and the case is reviewed, and so the equitable distribution claim was lost when that Chapter 7 discharge went through in the case that was reviewed. You would think that the same thing would happen with the Chapter 13. And the case went on to review other cases, as well as a federal case. It discussed the federal case of Walton versus Walton. And our Court of Appeals actually said that it's the fly in the ointment, the Walton versus Walton case out of the Eastern District of North Carolina. It's a district court case, or a federal district court case, U.S. district court case from 1995. Now, a district court case in the federal government is kind of similar to a trial court case here. It's not a Court of Appeals case. It's a district court case, but it is still persuasive authority. And the North Carolina court said it's merely persuasive authority, but then went on to say, but it is a federal court case evaluating and reviewing federal law, so we're going to give it some more significant weight. And what the Walton case went on to say is that a non-filing spouse, or the spouse who did not file for bankruptcy, has a proprietary interest in a military pension. Well, that's really interesting. And that proprietary interest is not dischargeable. Okay? But here we are saying that equitable distribution is dischargeable, the claim for equitable distribution. And if we discharge equitable distribution, then you don't have a way to get to the proprietary interest of the military pension. This case right now that we're talking about, the Brown case, did ultimately find that the military pension is a proprietary interest, that the non-filing spouse, or the non-filing bankruptcy spouse, continues to have a proprietary interest in that military pension that can be distributed to them under bankruptcy after this court went on to say that the non-filing spouse in a bankruptcy continues to have a proprietary interest in a military pension after discharge that can be divided in an equitable distribution. Well, that's a little hard because the equitable distribution actually sort of dies after the Chapter 13 bankruptcy is discharged. But the court went on to say, no, this is an extra special class because you could not have discharged, or the lien, the creditors under that bankruptcy could never have touched that military pension. It went outside of the bankruptcy. I think the problem here for the Court of Appeals is that if you say that bankruptcy discharges equitable distribution, and that you cannot have an equitable distribution after a bankruptcy, then you can't use an equitable distribution to divide a military pension. I think they needed to be very clear. Like, does it discharge an equitable distribution up to and including with the sole exception of a military pension? That's basically what we've received out of this case. I gotta be honest with you, I think if it goes up again, maybe to the Supreme Court, or goes up to another federal court, that this might be a different outcome, but I don't know if they're going to appeal it. So for now, if a military member who has a pending pension in their future from all of their service files a Chapter 13 bankruptcy and gets a discharge, that military pension is still on the chopping block for equitable distribution, even if they follow all the steps. Tell me what you think. Do you think that's fair? Do you think that's right? Do you think it's clear? Like, subscribe, and tell us what you want to hear about.